The Supreme Court is increasingly being pulled into the upcoming presidential contest due to 4 election-related cases on their emergency docket. On Tuesday, the court denied 2 requests from the former independent candidate Robert F. Kennedy Jr. to be taken off the ballots in the key swing states of Michigan and Wisconsin. Still pending is the Republican National Committee's challenge to who can cast provisional ballots in Pennsylvania, and Virginia officials can now cancel more than 1,600 voter registrations the state claims are held by non-citizens in advance of next week's election. That ruling was made by the Supreme Court earlier this morning. Let's go ahead and bring in Chief Legal Analyst Khalif Rhodes here to dissect a lot of what's happening with the court, as it's seemingly more and more that they're putting their hand on the scales when it comes to the election.
Hopefully my scalpel is sharp if I'm dissecting anything with all this, because it's extremely becoming murkier and murkier as we get closer to the election. What I can tell you is that the Supreme Court doesn't want to do this. They don't want to be involved in these types of cases. They always try to punt, either punt back to the lower court or make a decision not to grant cert and hear the case at all. That has been their normal practice, where we don't have to touch it, we won't touch it. But there's a couple cases that they are at least going to have to hear something, even if it doesn't happen before election. We got the RFK situation where, what is it, Wisconsin and Michigan, he was trying to get taken off the rolls. So you got to think about any state that is a swing state, any state that is a hot button state where they're
Pennsylvania and the other cases involved.
These cases are going to pop up. And so you guys ask me a lot of times, timing. You're like, look at the timing. Isn't it interesting of the timing? Yes, in this situation, the timing, I think, is something of particular interest. But I think the timing is going to hurt a lot of these cases, because you just don't have time to be able to address them, A, before the election, and B, before voters start in or already have voted. I look at Pennsylvania, for instance. They said 2.1 million folks requested a ballot to be mailed to them. 1.4 have already been mailed back. So if you're talking about how do we address any type of ballot situations in the state, it's going to be hard to deal with those situations where 1.2 of them have already sent them back in. I think a lot of this will be problematic, and the court may punt until after the election for sure. After
the election, because it's easier to do that just because of timing, but also discussing how they bring that up on a court's decision to bring it up on an emergency docket like that.
I mean, timing is an issue. You have to be able to state that there will be irreparable harm that will occur if you don't address this. And so counsel's going to be making the argument that if you don't make a decision, my client will be harmed to a matter where they can't be helped later. The court will make a determination to say, okay, this supersedes what our normal docket process would be, and now we're going to have an opportunity to hear this on an emergency docket. But I don't think, even if they hear it, a decision will be made before election date. And if you can make a decision, I have to defer back to what a lot of the lower courts are saying. How can we make a decision that affects a voter if they've already voted? So then are we retroactively removing their vote that they've already cast? And so what the court wants to avoid doing is A, causing any doubt or any shadow of doubt over the whole electoral process. But they also don't want to disadvantage a person or create more hysteria by saying, okay, even if we fix something that was wrong, in the process of fixing something that was wrong, have I now opened up Pandora's box to create 50 more problems? And that's what the court, that's why they punt on these situations most of the time.
All right, but they did know the Virginia case, but they still have the other cases.
In the Virginia case, I think that made sense. This is a ballot. They're asking for 1,600 people. They went through the process. The lower court said they didn't want to do it because of what I'm mentioning in my argument, that they didn't have time, that it happened within the 90-day period, which they are not supposed to remove. But the court is saying, no, we're going to allow it to be done. That process worked out like it's supposed to. Some of these other ones, I just don't think they'll have time.
All right. Chief Legal Analyst Khalif Rhodes. We have just 6 days now until Election Day, as it is heating up all across the courts as well.